Good morning and welcome to Catapult's Answers at 8. We're happy to have you with us this morning. So as most of you know, Answers at 8 is our weekly series to provide you with real-time HR and COVID updates. I'm Ashley Parrish and I'm one of the HR advisors with Catapult's advice team. I'm joined today by Phil Wells, attorney with Soul Law Firm, and Amy Tinsey, Catapult's COBRA Services Specialist. Good morning, Phil. Good morning, Amy, and welcome to your first Answers at 8 session.
Good morning, Ashley. It's good to be here. Thank you. Thanks for having us.
Yes, good morning. Hope everybody's doing well.
Great. And Amy is joining us by phone today, so you're not having technical issues. She is by phone, and Phil is joining me via video conference. So good morning to both of you, and thank you again for joining us today. Today, we're going to begin with a Q&A session on the new COBRA subsidy with Amy and Phil. And so we've gotten a lot of questions lately about this COBRA subsidy. And so we're going to do our best to cover some of those questions that we receive most frequently while we have the specialist with us this morning. And then we'll cover into some of our more general HR and updates with key dates and such. Keep in mind that we do want this to be interactive and we want to answer your questions as well. So please use that question feature in the control panel and we'll get to you as many of those that we can. If you're unable to get to your question, we will definitely reach out after the session. Also, we are recording today's presentation and that'll be posted on our website later on to view as well. So we'll dive right in. While some areas are still waiting DOL to clarify, Amy has some great information to those common questions we've been receiving over the past few weeks. So Amy, we're going to do just a good old standard Q&A. So first one that we have today is when you previously terminate employees, are they permitted to enroll and get subsidies? And does that coverage does it start at the time that they elect or is it retroactive?
Okay, an eligible employee can elect to enroll in just the subsidy period, which is from April 1st through September 30th, or up until the end of their COBRA period. It will not extend past that. So it's the 18 months, that will be it. They do not have to pay this retroactively.
Okay, perfect, thank you. And then another one we have is since employees already have the flexibility on picking up COBRA due to the extension of the election period, would that also extend to the time that they have to elect the subsidized coverage?
These eligible employees will have a 60-day election window for the subsidy from the date of the notice. So the suspended grace periods that are in place right now will not apply to this election notice for the subsidy.
Okay, gotcha. And then another one, and Phil, I'm going to toss this one over to you. So gross misconduct. So we understand that, you know, this subsidy applies to those that are involuntarily terminated, with the exception of those that have for reason of gross misconduct. So can you kind of elaborate on what gross misconduct means?
Yeah, so good question. The easy part is that employers are not required to provide employees and their dependents this COBRA subsidy if they were denied COBRA due to gross misconduct. The more challenging part is, so what does constitute gross misconduct? And there's no clear definition on that. It's a pretty high standard. So I took a look at some of the case law this morning, and it really varies jurisdiction by jurisdiction. There's one case I found by a federal district court. A flight attendant made a racial remark toward a coworker while they were in the air on a flight and then threw an apple at her. Well, the court said that's gross misconduct. But again, it's very fact-based, very case-by-case fact-specific. Generally, a termination just for cause probably wouldn't rise to the level of gross misconduct. Here's what I would say, Ashley. If you think you want to deny someone COBRA or this COBRA subsidy because of gross misconduct, consult counsel. That's probably the best answer we could come up with. It's very fact-based and a pretty high standard.
Absolutely, great. And I couldn't imagine being on that flight. Somebody had thrown an apple across, my goodness. So a great example. And then kind of to elaborate on top of that, so if a company doesn't use gross misconduct to disqualify people from COBRA, in a normal situation, would they still be able to use it to prevent them from getting the subsidy? And Amy or Phil, whoever wants to answer.
In this case, I would say you would need to follow the same guidelines as you would for gross misconduct. If you do not normally disqualify involuntary terminated employees due to gross misconduct, you would have to do the same for the subsidy. So be very consistent in documentation, all of that. It's very important.
Absolutely. I think everybody hears that from us all the time. Documentation is key. So great
Yes.
point. Well, what if they don't have a notice yet? And so we do know that the Department of Labor is supposed to be coming out with a notice, but since they don't have one yet, can they postpone notifying employees at this time?
Well, we are still waiting. The Department of Labor is expected to have the model notices out by April 10th. So employers and or administrators should be notifying these AEIs or assistance eligible individuals by the end of May, but not sooner. So if you have any COBRA participants that have paid for their premiums for April or after, before they are notified of that subsidy, they're giving us like a 60-day window to provide the refund back to them. So
okay, makes sense, definitely. Next question we have is, if someone who is in their COBRA timeframe now elects COBRA for the subsidy between April and September, do they need to go back and pay coverage for the past months when they opted out?
Actually, no, they do not. They will not be required to pay any of those retroactive premiums.
Okay, so anybody before April 1st, and then of course at this point it would be after September 30th, they're not required to pay, right?
Right, exactly.
Okay, perfect. Now, is this something that every organization has to do, or is it voluntary, similar to some of the paid sick leave and EFML?
This is mandatory. It is required. All employers subject to COBRA must abide by the new regulation. So,
Okay,
yes.
perfect. Yep, so unfortunately not voluntary, guys.
Right. Sorry.
Yeah, I know, right? What about, do we know anything of how they can get that credit for the tax credit side of it?
Well, my understanding of it is that employers will be reimbursed through tax credits against their quarterly payroll taxes for the cost of the subsidized coverage during that 6-month subsidy period. Beyond that, and Amy, I'll defer to you as well, but I would say consult with your accountant or your payroll provider, processor. That's probably the safest answer we could get. But again, Amy, I'll defer over to you as well here.
Yes, I completely agree. What I've heard so far, and I'm not the tax person, so it's provided to employers as a credit against their FICA payroll taxes. So definitely coordinate with your payroll vendors on that.
Absolutely. Yeah, definitely. And same goes from the advice standpoint. We don't pretend to be tax experts at all. So we have that conversation frequently. So moving on to the next question, what does involuntarily terminated mean? So if someone can't come back, for instance, from if they're on like an FMLA leave or an ADA leave, and they can't come back, is that going to be considered an involuntary termination?
Well,
go ahead.
Go for it.
No, I was just going to say that unfortunately this is still unclear. We are still waiting on some additional guidance from the Department of Labor, the FAQs, around these types of situations. So for these type situations with the FMLA, with any of the other involuntary terms like reduction in hours, employers will have to look at these on a case-by-case basis. I would think you'd have to just determine, and then once we have more guidance, we can share more.
Yeah, absolutely. I concur. I think we're absolutely going to need more guidance from DOL. I read a number of attorney blogs on this topic. There was one solely on, would retirement be an involuntary termination? And this particular pundit seemed to think it would. But again, as to whether someone could return from FMLA or ADA, I think it's going to depend on why they can't return from that. So again, I agree with Amy very much. So very fact specific, very case by case specific.
Yeah, absolutely. Yeah, and very good points, guys. Appreciate that. So just like with anything, it depends, right? It depends, and we need more clarification. Well, what about a voluntary reduction in hours? You know, due to COVID over the past year, that has happened for more employers than not, of having to reduce hours. So is that going to be considered a qualifying situation?
The voluntary, even if it's a voluntary reduction in hours, this would not be eligible.
Okay, all right. And is that because it is voluntary, quote unquote?
Yes.
Okay.
Yes, because I've actually had that question too, where voluntary decide to go from full-time to part-time, then that would not be eligible.
Okay, makes sense, definitely. And does this include only employees, or does it include those dependents as well, or dependents that were on their insurance?
This is going to include employees and dependents. If they are under, you know, we have to still look at who's considered a qualified beneficiary under COBRA. So for those who are covered immediately before the reduction of hours or involuntary terms, which these are dependents under that employee though, they would be eligible for the subsidy. The dependent, the actual dependent events like ineligible child, divorce, death employed, those type of events, those are not eligible for the subsidy.
Okay, perfect. Makes sense. And I appreciate all of that. So great information. I'm actually going to pause and kind of jump over to our questions. We've gotten quite a few coming in on this subject this morning. So Amy, I will read those out loud. If you can help me answer these, I greatly appreciate it. So our first one is it frowned upon offering all termed employees COBRA?
Let's see. Frowned upon, well, it's a requirement. So, I mean, is this regarding the subsidy or just in general? Because if they have coverage. It appears
to be in general, and that's all that they included in that question. They may elaborate here in a minute. But yeah, I would answer it, I guess, in the terms of in general, you know, if a company is offering COBRA to all termed employees, is that frowned upon? Or, you know, to your point, you know, if you're a COBRA eligible employer, you know, you're supposed to provide it to all terminated employees. So we may need some more clarification there, Joanne, in that instance, and we can always follow up with you in an email afterwards as well to clarify that for you.
But if they do, I was going to say, if they do, you know, if you're have 20 or more employees and they do have coverage, of course, your eligible coverage, then yes, you are required to send the notice to the employees and dependents. So
okay, perfect. And as I said, we'll be happy to follow up to get clarification on that one also. Our next one is, what is the time frame for those that are eligible? Is it November 1st of 2019? And then when does that go to?
The look back period, it does go back to November 2019 because if someone is termed within that time frame, they would have maybe 1 month of subsidy. It would end in April, so they would potentially have that 1 month. So we do have that look back period. It's going forward even for the future terms until they let us know that it's no longer going to be provided. So, and of course, if these people do elect again, it would just be, they can take it just for that subsidy period.
Okay. And so you said that, so at this point it's going from November 2019 and then ongoing?
Yes.
But that's still within their 18-month qualified period, right? Okay.
Exactly. That they have to still be in that COBRA period.
Okay. Absolutely. Thank you. So our next one here, and I'm typing these in so people can see them as well. So our next situation is they're terminating somebody this week. Should they at least let them know that the COBRA payment will not need to be made after enrollment and through September?
Well, right now the COBRA notices haven't been updated.
Good point.
And they need to be, you know, we're still waiting. And these employees, you know, we need to make sure that they are determined in AEI and eligible. So, I mean, if you know, if the employers are doing this, I don't, you know, I think it's okay to let them know, but there's always we have those grace periods too. So, which are also suspended. So it's very confusing, but
Absolutely.
they could go ahead and elect and then wait to pay, and if they are determined to be eligible, then they would not have to pay at that time. So
Okay. So
for
in
the
this,
subsidy.
yeah, best estimate would be if you definitively know, that they're going to
Mhm.
qualify for it, you could have the
Yeah.
conversation, but just let them know that you are waiting additional information to provide for
Yes.
them.
Yes.
Great. Next one says, does the COBRA subsidy apply to medical insurance only and not dental or vision, or does it include dental and vision?
I have heard that. I mean, I know I've heard both sides. We're still waiting, but I'm thinking it's gonna be the medical, dental, and vision. No FSA, but it will include the dental and vision, I think.
Okay, but that is one of the areas we're waiting on the DOL, right?
Yeah, but I
Okay.
have heard more so that it will be covered.
Okay, perfect. And I had the next one is it a federal or state mandate? And so this is part of the new American Rescue Plan Act. And so this is coming out from a federal standpoint for that question.
Yes.
And then if a qualifying participant would be eligible for April through June, I'm going to assume they didn't put years in here, so I'm going to presume that that's April of this year through June of this year. But notification doesn't go out in time for them to sign up in that time frame. Can they get it retroactively?
Yes, if it's for the subsidy period, if it's for 2021, yes,
Mhm.
it can be retroactive because we've got until May 31st to get the notices out, or employers and administrators. So
Okay.
a lot of these will be retroactive.
Good point. Okay. So, and just to kind of clarify that, because I know we said earlier it's not retroactive, but that would be retroactive in the sense of before April of this year, outside of that November 2019 timeframe as well. So, one of those areas of a lot of new information coming out here. So we've got some great questions coming in here. The next one is, if a person voluntarily requests to move to a part-time position, are they now eligible for the subsidy? So I know we talked about that, but Amy, can you reiterate that one for us, please?
Right. If it's a voluntary moving from full-time to part-time, any voluntary situations, they will not be eligible for the subsidy.
Perfect. And then what about a contract employee whose contract ended? Is that considered an involuntary termination? Well, and if you're a contract employee, Amy, correct me if I'm wrong, if you're a contract employee, you're not receiving COBRA anyway, correct?
Right, if they're not considered, yeah, because they wouldn't have that coverage. So I think that's my understanding.
Okay.
Yeah.
So perfect. Okay. I think we're getting kind of to the end of these, but let's see. Oh, so that one is about the vaccine, so we'll hit on that in just a moment. How about if a municipality provides health insurance to a council member and the council member loses an election? So they're not an employee. Would they be eligible for COBRA coverage? And would that be considered involuntary termination? So I believe that would be kind of the same as a contract employee, but Amy, do you want to elaborate on that?
I am a little unclear on that one.
That's okay. We may need to respond to that one via email unless Bill, you want to chime in.
Yeah, I'll just jump in and say that there's one of the blogs that I read that specifically said if someone loses an election, they would be eligible for COBRA. That's one, though, that I would say we really ought to research further and get back to you with a clear answer on that.
Absolutely. Perfect. And so we'll be happy to respond to you via email once we have some better information for you, definitely. What about, is retirement considered voluntary or no?
Well, this could be something we need more guidance on. Typically, they are voluntary, so they would not be eligible for the subsidy, but there are situations that it could be an involuntary type of retirement.
Exactly. And here again, the pundits, we get answers. It depends, and I think it will depend. I don't think there's necessarily a clear-cut answer on this. I read one pundit's blog yesterday that said retirement would qualify someone for COBRA and thus the COBRA subsidy. But again, probably ought to look it down on a case-by-case basis and get some further clarification on that as well.
Yeah,
Absolutely. Great. And then looks like, so our next one, what happens if a current COBRA participant makes the payment for their benefits during the subsidy period and then is eligible for the subsidy? Do they receive those funds back? That's a great question.
Yes, that has been put out in the regs, regarding the refunds. You have 60 days to refund that person if they are found eligible for that subsidy, and then they have already paid. You do have to refund that money back to them.
Perfect. Okay.
Yes.
Great. And then let's see. So is it correct that the COBRA premiums are paid 100% for involuntary terminations, regardless of whether the termination was COVID related or not?
Yes.
Yep. Definitely. Yeah. So this is not just for COVID. This is for any reason that was involuntary. If so, this actually elaborates on our contract employee question. So let's consider that an employee or a contract employee was covered by an employment agreement, and the specific term has an end date in that. So if the company says you will not continue as an at-will employee afterwards, would that be considered an involuntary termination? And Phil, that might be kind of more your area.
Well, here again, I would say, and of course, this is another one of those, right? Well, it depends, but I do think it depends. I think that's an instance where we'd have to look at that employment contract and look at it in its totality and see. I just think we'd have to know more about that situation to really give more than an "it depends" answer.
Okay, so and we'll be happy to discuss that. We can reach out to you later on and have a more in-depth conversation, see if we can help out in that situation too. Great. So I think we are reaching the end of our COBRA questions. And Amy, I can't thank you enough for being here today as our COBRA specialist and answering those. So if we receive more through the questions, Amy will remain on to kind of assist in that area. So again, thank you. So yes, we will continue on. We'll continue on though with the rest of our segment. So for the remainder today, we're going to review some recent legislation and key dates as many items have gone into effect in the past week. So, and then we're going to discuss some vaccine strategies as well. So to start off with a recap of a few items over the past week. So note that on on March 30th, Governor Cooper signed Executive Order 207, and that extended the unemployment expediting provisions that were originally from Executive Order 184 last December. Those are now extended through June 30th of this year. So that also, just keep in mind, that provides employers that ability to file an attached claim for employees' unemployment. So where that includes if you need not require an employer to pay the division an amount equal to the full cost of the attached unemployment benefits. It also means that they not reject a partial unemployment attached claims if they're exceeding 6 weeks. They're not going to reject a partial unemployment attached claim if they're submitted more than once during a benefit year in regards to one employer or another. And it also means that they'll accept claims by employers who don't have a positive credit. And so all those provisions have been extended again through June 30th. Also beginning today, all North Carolinians age 16 and older can get their COVID vaccine. So I'm going to put that link in the chat box for us, the myspotnc.gov, for those needing it. Encourage employees and everyone to be safe. And if you're willing to get vaccinated, you can go on there and find your location. And then just a reminder that last week, the EEOC announced that it'll open its website for the EEO1 component data collection. And this is for the 2019 and 2020 data. That's going to open on April 26th. And right now it has a deadline of submission of July 19th. And so we did finally hear from them. Again, that opens on April 26th. And then Another update, again, we have a lot of information over this past week. The I-9 flexibility has been extended. That was updated on March 31st by USCIS. So that flexibility announcement was issued on March 20th, and it notes that DHS will evaluate certain COVID-19 related Form I-9 completion practices on a case-by-case basis. And that is related to the physical inspection of the Form I-9 documentation. So as of April 1st, the requirement that employers inspect employees' Form I-9 identity and employment eligibility documentation in person only applies to those who physically report to work at a company location on any regular, consistent, or predictable basis. And so if you are still remote, if your employees are still remote, the flexibility to not do that currently in person is still there. It's only required for those if they are truly coming in on a regular and consistent basis. And that has been extended yet again. So that information I'll also put in the chat so that you can read through it. And then if you have questions, feel free to reach out to us on that. And then finally, OSHA has stated those who missed the March 2nd filing for your 300 logs this year, you can still submit those through the end of the year. And so if you need to do an electronic submission, you're still required to do that, but you do have it through December 31st of this year if you've missed it. So a lot of updates there, right? We've also received, just to kind of change over to some of the EFML and the traditional FMLA, we've gotten a lot of questions lately on how do those two interact. For instance, does taking expanded FMLA exhaust the traditional FMLA simultaneously? Or do employees get a new bucket of the EFML leave as of April 1st? So Phil, can you shed some light on any of these questions?
Well, we're certainly getting a lot of questions on all of this, aren't we? And it all can be a bit confusing. So let's try to peel back the onion just a little bit. I think first and foremost, as most everyone probably does know, so the American Rescue Plan Act does not renew the requirement that employers provide their employees with paid or unpaid leaves of absence related to COVID-19, as was originally mandated by FFCRA almost a year ago. ARPA, and don't you love all these acronyms? ARPA does extend and expand the availability of payroll tax credits if employers voluntarily provide paid leave consistent with FFCRA and now ARPA. Big question, one we get a lot, do employees get a new bucket of EFML leave as of April 1st? Well, again, not clear. We're really waiting on further guidance from DOL on this point. There's a lot of discussion amongst the legal pundits, and my colleague Jim May and I were talking about it yesterday. You read one blog that says yes, and you read another one that says no. So we're really not sure at this point, and we do need further guidance from DOL on that. It creates a new bank of up to 10 days per employee of qualifying paid sick leave that's available for tax credits in 2021, beginning on April 1st. Thus, the amount of the tax credit per employee has increased from $10,000 to $12,000. ARPA broadens the COVID-19 related sick leave reasons for which an employee would qualify for paid sick leave. So there are three new reasons for the paid leave: getting tested or awaiting test results or medical diagnosis for COVID-19, getting the vaccine, and recovering from an illness or medical condition associated with getting the vaccine. Those expanded sick leave reasons are now included as qualifying emergency family medical leave reasons for paid leave under FFCRA. And finally, I'd note that ARPA disqualifies employers from receiving a tax credit if they violate FFCRA, such as the anti-retaliation provisions, or they violate the non-discrimination rules by administering FFCRA paid leave benefits in a discriminatory fashion in favor of highly compensated employees, for example. So there are a lot of moving parts to it, and we are getting a lot of questions. And here again, we're hoping that before too long, we get some further guidance from DOL on some of this to help us peel back the onion even further.
Right. And Phil, thank you. It's great information. And I understand the FLSA, also finalized the tip regulations. So do you want to speak on that? 'Cause I know we have quite a few members who are in those industries.
Yeah, and so it's interesting. This is one that's kind of flown under the radar screen, and I think COVID has been in the news and related issues so much that this one hasn't gotten a lot of press or attention. Last December, DOL published tip regulations under the FLSA final rule, which were to take effect March 30th. They were to have taken effect. But earlier in the year, under the new administration, DOL came forth and put all of that on hold. But what they did do is say that they're going to move forward with two parts that become effective April 30th. So here again, to your point, any members who are in the restaurant industry or the hospitality industry and collect tips very much need to be mindful of this. So the following provisions of the final rule will take effect April 30th. If an employer does not take a tax credit or a tip credit, I've got taxes on my mind. If an employer doesn't take a tip credit, it may allow workers, back of the house workers like cooks, dishwashers, to share in a mandatory tip pool. Now, under those circumstances, there are some new record keeping obligations that apply, but that's intended to share the wealth, if you will, a little bit with the collection of tips. And the second thing, employers, managers, and supervisors are explicitly prohibited from keeping tips received by employees. That's a very high level view of those two rules that take effect April 30th. There are still proposed rules that go back to what was to take effect the end of March. So proposed rules still under consideration by DOL, and DOL has invited comments from the public on these further rules that are under consideration at www.regulations.gov. I would say, and so it's open to comment from anybody in the public, but I would certainly say to any members who are in the restaurant industry, this is your opportunity to go online and comment on those proposed rules.
Yeah, absolutely. And I will put that link in the chat for everybody as well. So, and definitely anytime that, they ask for your opinion, it's always a good opportunity to go in there and provide it. So wonderful. So thank you, Phil, for those updates. Really appreciate it. I will say, so the Internal Revenue Service, or IRS, did issue some guidance for employers claiming the Employee Retention Credit under the Coronavirus Aid, Relief, and Economic Security Act, or the CARES Act. That was modified by the Taxpayer Certainty and Disaster Tax Relief Act of 2020, or just the Relief Act. Again, all those acronyms, right? This Notice 2021-23 explains the changes to the Employee Retention Credit for the first two calendar quarters of 2021. So what it includes is it increases that maximum credit amount. It also has the expansion of the category of employers that may be eligible to claim the credit. It modifies the gross receipts test. It revises the definition of qualified wages, and then has new restrictions on the ability of eligible employers to request an advance payment of the credit. So as a result of those changes made by the Relief Act, eligible employers can now claim a refundable tax credit against the employer's share of Social Security tax is equal to about 70% of the qualified wages that they pay to employees after December 31st of 2020 through June 30th of this year of 2021. Those qualified wages are limited to $10,000 per employee per calendar quarter in 2021. So thus, that maximum employee retention credit available is about $7,000 per employee per each calendar quarter, for a total of $14,000 for the first two calendar quarters. So I'm going to put a great link in there. As we mentioned earlier, we are not tax experts, but this is definitely important information for our members to receive, and important as you guys are just like all of us vetting through all of this new information and all these tax credits. So the Form 7200, which is the advance of employer credits due to COVID-19, that of course has some certain limits on it as well. That reduces the deposits. And keep in mind that in 2021, the advances are not available for employers that are are larger than what is considered the small employee. So an average of 500 or fewer full-time employees in your 2019 records. So those details on how to calculate and claim are in that notice 2021-23. And again, I'll put that in the chat so that you have that. Additional coronavirus relief information for businesses is also available on irs.gov, and all those links will be in our chat for you. So Phil, I'll hand it over to you. Talk a little bit about wages.
So further to that, Ashley, wages paid for any leave taken under FFCRA had to be reported on an employee's W-2 as such. And while reporting instructions were contained in an IRS notice last June, they were not explained in the actual Form W-2 instructions. And so some employers may have missed out on that. And I think we've gotten some questions about just that. They're having missed out on that. So I think you're also going to post in chat an article with some information about how to correct that if you need to go back and do so. And I think IRS has come forth specifically and said, if you missed it because we didn't give you enough information, then here's how to go back and correct that. So that's certainly something that employers need to be mindful of.
Absolutely. Well, thank you for that.
Sure.
And as a reminder too, there are some new North Carolina labor law poster requirements. And so that has been updated with some information. So some of those updates include the workers' compensation notice to injured employers and workers, that certificate of coverage and notice to workers as a benefit right, and then the Wage and Hour Act notice to employees. And so be sure to update your labor law posters. That is something we can assist you with. Feel free to reach out to us and we can get those new North Carolina ones for you as well. So
yes,
Phil, and
well,
I would pause here for just a minute and go through some of our questions we've been receiving, see if we can't help out these. One of them is what are your thoughts on requiring a new hire to get vaccinated before a company hires them?
Well, there's certainly reasons that an employee or potential employee may not want to or be able to get the vaccine. And I think you're going to have to look at those on a case-by-case basis. There's been a lot written about that, sincerely held religious beliefs, ADA. So I think a blanket prohibition is not a good idea. And again, can consult the HR advice team or counsel to get further guidance on that. I just don't think there's a blanket one size fits all answer for that. Although we're getting that question a lot, that type of question.
Yeah, we certainly are. And this one kind of is similar to it. So, but just to make sure that we cover it, see if you have any different thoughts on it. The question is, as we require all remote workers to come back to the office, if an office employee has stated they didn't get or they're not going to get the vaccine, and then a remote associate who's vaccinated refuses to come back because that creates an unsafe environment, can they terminate the associate that won't come back, or can they terminate the one who is refusing the vaccine?
Wow, I'd be very careful about terminating anybody for any of those reasons, quite honestly. And again, I think we'd have to say, well, it depends, and we'd have to jump in that a little further. I know before we were going to close today, Ashley, we were going to talk about a number of great resources around safely reopening the workplace. And I know we are getting a lot of questions as companies start to look at reopening the workplace. And there are two great resources out there, one that's offered up by OSHA and another that's offered up by the CDC. And it talks about measures to take to ensure that as you reopen your offices and your workplace, that you do it in the right way and the best way. And quite honestly, I think there are a lot of issues for which there are not going to be clear answers. And we're going to have to look at these as we go forward. This is new territory. This is new ground. And I think here again, it depends. And we're just going to have to look at a lot of these on a case-by-case basis and kind of chart the way forward all together as we go forward.
Absolutely. And I think that's a wonderful transition into our next topic, which is about the vaccine strategies. And so we wanted to, share some information with all of our members in regards to some strategies that we, recommend, as well as those that we're hearing and from other members. And so, of course, one of the biggest questions that we receive is whether to mandate the vaccine or not. And so whether do we ask for vaccine statuses, is that, and that's definitely something that is top of mind for a lot of employers. So Catapult has several tools on our website that are available to members and non-members. And we want to take a moment to highlight those for you to better assist during these times. Keep in mind that these resources, they have been vetted for federal and North Carolina compliance. If you're in another state outside of North Carolina, please be sure to check that state law to make sure that they are going to be compliant with any local legislation or executive orders and such. But if you go to the letscatapult.org website and select resources, resource library, and then filter by COVID on the left panel, you'll receive several documents. And I will be sure to put that information right now in the chat for you all as well. So one of those documents is a voluntary COVID vaccine policy. It's not so much a policy as it is the company's stance on vaccines. And the purpose of that is to encourage and educate employees. It may, be useful in doing either on-site clinics and things of that nature. Another one in there is a mandatory vaccine policy. So that can be used as a policy if you do decide to mandate the vaccine. Keep in mind that if you're going to mandate it for some jobs, and not all, for example, you may decide that only customer-facing jobs need to have the vaccine mandated, but the back office doesn't. So you can do things like that. Also, think through remembering to consider those accommodations. So if an employee has a sincerely held religious belief that prohibits them getting a vaccine, if they have a serious medical condition and where a healthcare provider has advised them getting the vaccine, or if they have an objection based on the emergency use status. So what that means is keep in mind that the EEOC is not formally weighed in on this yet. And this vaccine is one that is issued under the EUA status. And so there is some debate back and forth as to whether or not you can actually mandate it. So, but again, EEOC has not come out with any further clarification in that area. But as of now, if an employee falls under one of those three categories, you would need to, provide an accommodation, especially for the first two, and the third, it would be a conservative approach. We'll say it that way in order to provide that. Another tool under there is the voluntary vaccine acknowledgement form. So you can use that form when employees decline to get the COVID vaccine, and it's just a tracking mechanism for it. And then the vaccination planning tool, so that's a checklist that you can use to help determine the right strategy for your organization. We get this question a lot on the advice line, but at the end of the day, it really does depend on what's going to be best for your company and your population. And so this is a good tool to use to help determine that. It has a series of yes and no questions that will help you guide in making, what makes the most sense for you. And then we also have an FFCRA policy and form template that includes a certification form with those new expanded leave reasons under the ARPA. So if you're looking for an easy way to have your employees document their absences, you can use that as well. So Phil, is there anything you'd like to add?
Well, I see we're getting a lot of questions about the vaccine and mandatory. Can we do it? Can we not do it? Just give us an answer. And again, I'm just going to say, I think it depends. And to your point, the EEOC has not formally weighed in on this. We keep thinking that they're going to do so, or we're hoping that they're going to do so, that there's some further guidance on this. But I would say, I would personally say, before you enact a mandatory vaccine policy, consult with the HR advice team, consult with counsel, and let's talk through the pros and cons of that. And so I'm going to give you an it depends answer for the most part now. I know, and I'm just seeing the questions come through. There are a lot of them. And I get that. It's a hot topic. Hopefully we will get further guidance from EEOC on this one. Fingers crossed, right?
Yeah, absolutely. Every day we wake up waiting for that to come through, right, Phil? Um,
Exactly.
One thing we can, so I did see a question here that says, who needs to know whether employees, have been vaccinated? So again, I recommend using that tool that we have on our website to determine, do you need to know if an employee has been vaccinated or not? In some instances, we hear from employers that they want to know because once they reach X percentage of those being vaccinated, they'd like to reopen their doors and what have you. And so if there's a business need for that, then certainly. We do know that you can obtain a copy of the vaccine card. However, ADA, keep in mind that as a medical inquiry, you need to not ask for anything beyond that. So it's okay to ask, have you been vaccinated, but we cannot ask, why or why not. We also don't want to ask for additional medical information, any of the screening questions, anything of that nature. But certainly if there is a business need there, then, HR would be best to have that. Keep in mind, it needs to have all the same confidentiality treatment as other medical information for your employees as well. And as Phil mentioned, we put in the chat as well 2 great documents. One's from OSHA and the other is from the CDC in regards to reopening. So we certainly recognize that while some organizations reopened last year, it is still an ongoing process for many people. And so those resources are now in the chat for you to reach as well. So Phil, is there anything else you'd like to say in closing today?
I would say those are great resources, Ashley, that I would encourage everybody to take a look at.
Absolutely.
Again, beyond that, fingers crossed for some further guidance on all of this. So
definitely. Well, Phil, thank you again for joining us today. And Amy, we greatly appreciate all of your COBRA guidance today. As always, the advice team, our legal team, and our benefits specialists are available for you if you reach out. But I think that's going to wrap it up for us today. So thank you again for joining and for your participation. Working together in this manner definitely makes us stronger a community, and we get to learn from each other. So we will see you again next Wednesday, same time, same place. Bye for now.